laws and considerations and board directives that are being discussed right now in this moment of time that really criminalize people, human beings, for being outside, for not having somewhere to live. And we at Destination Home, and we've partnered with Homebase and several others that you'll hear from today, um, really want to partner with the community to do something about it. We want to make sure that there are resources available to the people impacted, to homeless individuals, as well as partnering with cities, counties, and different jurisdictions in our area to make sure that we're remaining solutions focused. So this webinar today is really to invite you all to hear from our partners at Homebase and others, specifically about what all of these recent decisions and executive orders, et cetera, mean and don't mean. But most importantly, we want to partner with all of you on how we move forward and create solutions that work for everyone in our community. So we have partnered with Homebase's Criminal Legal Systems Initiative uh, to create coordinated community response. Um, and we're really using the guiding principles that you have on the screen as kind of our true north, so to speak, in this work. This is complicated, controversial work that often involves, multiple factors where, for example, we might be pitting environmental concerns with homelessness, right? These are challenging topics that there is really no right answer. And so it's about navigating these complexities and coming up with the best solutions. But first and foremost, like we shouldn't be making it harder for people to survive who are literally living outside and are already in traumatic survival mode circumstances. And every human being has a right to exist in our community. I was just asked this morning on this topic, what rights do homeless people have? Well, they have the same rights that all of us have, right? Because they're human beings. But it is a fundamental question that really helps you think about like where our society is going and what a slippery slope we could go down if we start thinking of homeless people as different types of people. We also know that carceral approaches are not effective. They're inhumane. We have ample evidence that our criminal justice system has issues, right? And is a warehousing solution, and it does have a time and place. But for your average homeless person, that's not the solution that's going to help somebody get out of homelessness. And in fact, it makes it harder for somebody to get out of homelessness when they start racking up fines, fees, criminal penalties, court dates, etc. And oh, by the way, all of this impacts people of color more than the average person. And what we know is that we do have solutions that work. We have housed in Santa Clara County nearly 16,000 people over the last 4.5 years, which is an incredible feat and is not something that's done alone. It takes every single person who's on this panel and many, many more. We have solutions that work. We just need more of them. There is a dramatic lack of affordable housing in this community and across the country that is really driving our homelessness crisis. And so, knowing that, we really are encouraging our communities locally to step up and not say, okay, we know that it's a lack of affordable housing and a lack of an ability to pay for housing. So we don't know how to build housing fast enough. So let's criminalize homelessness. And that's kind of what we're seeing that we could go. So I'm challenging all of us to come together today and kind of going forward and making sure that Santa Clara County, Silicon Valley does not become one of those communities that takes these recent decisions as an excuse to go ahead and push people out and criminalize homeless people, but rather to come together and find solutions that work for everyone. So that being said, we have an incredible panel of people and a wealth of information that we want to share with you all. We are recording the core of the presentation today, just the content, so that we can have, a YouTube video that people can use as a resource down the line, but not the conversation piece, just as an FYI. And we do have opportunities throughout the presentation today for engagement and a little bit of question and answer time. So we will do our every effort that we can to involve everyone that wants to be part of the conversation. But first, I'm super grateful and excited to introduce you to Santa Clara County Supervisor Susan Ellenberg, who's here today really as a champion for our people on many different fronts, but today to share her thoughts around this rise in criminalization that we're seeing locally and hopefully how we can stay focused on the solution. So I'm going to be quiet now and pass the mic to Supervisor Ellenberg. Thank you so much for being here.
Thank you so much, Chad. I'm really looking forward to today's conversation and happy to start off with a few of my thoughts. As Chad noted, I'm the president of the Board of Supervisors for Santa Clara County. Counties are at base the social safety net servers. So we are very quickly looked to as the ones who should be addressing the needs of people who are experiencing homelessness. What's really important to distinguish is that cities truly are most often the builders, the infrastructure level of government. So one of the challenges in addressing homelessness is that intersection between who does infrastructure, who does services, how do we work together? But let me share a couple of examples of recent increased efforts to criminalize homelessness and how we are addressing them both at a county level and at a state level. I'm sitting as the second vice president for the California State Association of Counties, and everything that's happening in Santa Clara County is happening to some degree across the state. So of course we have the grants pass decision that we are all familiar with. And I'll tell you that counties and many cities were in a really awkward position around this because principally cities and counties want local control. And the premise of Grants Pass was local control. Cities and counties could make decisions about ordinances regarding camping, regarding other experiences of people who are living unsheltered. In the best of all possible worlds, we have local control and no jurisdiction abuses that to criminalize homelessness. As we're already seeing in the wake of the passage of Grants Pass, that criminalization is in fact happening. And I'm reading about city and county after county that are in passing and enforcing anti-camping ordinances. They're in a big hurry to go in and dismantle. But when I talk to my colleagues up and down the state, no one has good information or answers about where these folks are actually going. So we're not solving a problem with these ordinances. We are simply pushing it around our localities. An ongoing challenge that we have had, frankly, with the state and largely with the governor, is a lack of consistent ongoing funding. Governor Newsom's a big fan of year-to-year funding, which makes it very challenging to invest strategically. And now he's using that money pot as if it was a children's allowance to say, I'm going to withhold your money if you don't do something more about homelessness, which is entirely incongruent with actually solving the challenge. But here we are. Prop 36, which is on the ballot this fall as truly as a panic response to growing numbers of people who are experiencing homelessness. It is allegedly and purportedly meant to be a gap filler for Prop 47, which really brought our state forward in terms of criminal justice reform and thinking more progressively about how we address issues of substance use, of addictions, of mental illness, of the fact that so many people are experiencing homelessness. And instead of addressing those challenges, we have got this massive bill right now, massive proposition, which is unfortunately way ahead in the polls. And I've listened a number of times to the Sacramento district attorney, who is a very strong advocate of Prop 36. And in every conversation, he talks about the problems of homelessness and mental illness and substance use disorder. That's what he is trying to address. This is not truly about addressing some mythical concept of rising crime. So I'm going to put that on the shelf as a second piece. The third that I would talk about is the expansions in access to mental health care over the last couple of years by the state legislature, specifically looking at things like care court, SB 43, Prop 1 that's on the ballot. There's a lot of motion around we've got to better treat people who have serious mental illnesses and substance use disorders. For sure, that's true, we do. The way to treat them is not necessarily to compel them into jail or jail-like facilities to gather that treatment, so to accept that treatment. So again, we are dealing with really a state legislature, with so much respect to so many of my colleagues there, who are trying to throw literally every remedy at this other than investing at scale in permanent housing and homelessness prevention. They want to tackle this by just about any other source and any other strategy, and that's frankly frustrating. I am very grateful that the leadership in Santa Clara County truly understands both the distinctions and the overlaps between the experience of homelessness, the experience of serious mental illness, the experience of substance use disorders, and we are being very intentional about how we treat each of those conditions in sometimes separate and sometimes overlapping ways. But I think we are going to see more and more of this. I'm deeply concerned that Prop 36 is going to pass, and we're going to end up just putting more people in jail, which is of course much more expensive, but somehow still is that that lowest common denominator that so many municipalities feel is just the easiest solution. So that's probably enough for me as a start. I'm happy to share much more about specific policies, actions, and advocacy that we're taking around the state, and ways in which I am confident that Santa Clara County will continue to fight back and hopefully be a model for the state. Thanks.
Thank you so much, Supervisor. We really appreciate you being here today. So we will now turn to our presentation. So as has already been mentioned, presentation portions will be recorded, but open discussion will not be recorded. These slides will also be made available from Destination Home. Because we are in a webinar, you will still be on mute. So to participate in the discussion, please use the chat. If you want to participate verbally, please raise your hand and then we will unmute you so you can verbally share your comment, your question, or your concern. In the chat, please make sure to introduce yourself with your name, your title, and if you're part of an agency or organization, please include that organization or agency. Our objectives today are going to be to increase community understanding of Grants Pass versus Johnson, as well as Governor Newsom's executive order, that is EO N124. We will also be learning about strategies and campaigns for reducing criminalization of homelessness. As part of our discussion, we will focus on identifying which strategies and campaigns might be effective in Santa Clara County. So we have started with our introductions and opening statements. For the rest of this webinar, we will again review Grants Pass versus Johnson and talk about the Supreme Court decision and executive order. We will look at what criminalization can look like in Santa Clara County. We will review effective strategies for reducing criminalization of homelessness. And then we will move on to group discussion. Once again, the group discussion will not be recorded. Only the presentation will be recorded. And to participate in this group discussion, the two ways that you do that are to raise your hand so we can unmute you, or please put your comment in the chat. We will also be using Mentimeter or Menti for part of our discussion, but we will turn to that in just one moment. Finally, we will end talking about evaluation and next steps. As a brief legal disclaimer, the content in this presentation is provided for information purposes only and does not constitute legal advice. Homebase does not enter into attorney-client relationships. So we have a lot of wonderful presenters here today from the Prison Project, Law Foundation of Silicon Valley, Destination Home, and Homebase. Next, let's turn to our first opportunity for engagement. So what you see in front of you is a QR code, which you can scan and it will take you to a website. Alternatively, you can go to menti.com and enter this code. The code is 25169926. This will also be shared. Thank you, Vanessa, for sharing that in the chat. So when you go here, you will see a prompt, and we're going to do our first prompt, which is, what does criminalization of homelessness mean to you? So I'm going to give it one more second so that everybody can get to where they're going, and then we will look at the Menti screen. All right. So let's move over to, there we go. All right, let's make sure everybody's seeing what they should see. There we go. Look at all of those responses. This is amazing. So we already have 110, 118 responses. So what this is doing is creating a visual of what criminalization for homelessness means to all of us participating here today. The words get bigger when more people share them. So I think some of the big things that we're hearing in this community is that criminalization means injustice, unjust, inhumane, wrong, heartless, lack of compassion, violence, trauma, expensive. Yes, injustice, unjust, and inhumane seem to be, and violence seem to be some of our biggest ones. I also see waste. And I have someone who asked again about sharing and recording. Yes, we will be sharing the recording and the slide deck. Has everybody had an opportunity? Wonderful. I want to thank you all for sharing with us in this Menti. If you are using Menti, don't log out just yet. There will be another prompt and another opportunity for engagement using this platform in the future. But we will be using the same website, same code, same QR code. And now I shall go back to our slides. Oop. There we go. On to our next section.
Thanks, Chris. Hello, everybody. Welcome. My name is Vanessa Spinazola. I am the Criminal Legal System Initiative Strategy Lead at Homebase. I am happy to be here with you today. Well, happy, I guess, is relative because of the subject, but I'm going to talk to you a little bit about grants passed and executive order. I think most folks know a lot about it right now, so it's really just going to be kind of a quick run through. If folks have questions, they can put their questions in the chat. So we're here to talk about grants passed. Next slide, please. So as case background, this case started back in 2018. Deborah Blake, who has now passed, was one of the main plaintiffs. The ordinance in Grants Pass, Oregon, prohibited, among other things, sleeping in streets, alleys, or doorways, or camping on sidewalks or public property. And that also included basically with a covering. So it was very specific to people who had some sort of covering over them that weren't in a tent. That's what the ordinance prohibited. It included fines. Unpaid fines led to what they called trespass orders, which barred people from staying in parks. And then violating those exclusion orders could lead to 30 days in jail. And as a note, Grants Pass did not have any public shelters. They only had a gospel rescue mission. And there they required Christian services every day, among other rules, including having to work with no real track record of making accommodations for people with disabilities. Next slide, please. So the majority opinion in this case, which you all probably know by now, is that ordinances like that do not violate the Eighth Amendment's cruel and unusual punishment clause. There's a couple clauses in the Eighth Amendment. I'm going to talk about that in a minute. But the court decided, the majority opinion decided, this was not a violation of the Eighth Amendment. Basically because they said the Eighth Amendment is about the method of punishment, not what can be criminalized. So it's about the death penalty or, other types of excessive punishment. And they said basically using fines and potential jail time is not cruel and unusual in this case. There was a lot of discussion about whether homelessness was a quote unquote status. There's this other really big Eighth Amendment case called Robinson that was about the status of being an alcoholic. So if you listen to oral arguments or you skim through the opinion, you'll see a lot of talk about that. Ultimately, the majority opinion said homelessness is not a status like being an alcoholic. So therefore, you're not entitled to any sort of exemption under the Eighth Amendment. And they did acknowledge in the majority opinion that addressing homelessness is complex. And again, to Supervisor Ellenberg's point, that local government should determine whether criminalization is appropriate or what's appropriate at the local level. So next slide, please. As with the court, there's a majority and there's a minority. So in this case, there was a minority opinion as well, which their opinion was that the ordinances do in fact violate the Eighth Amendment's cruel and unusual punishment because sleeping outside when you don't have anywhere else to go is an act and it is cruel. And that actually defines what it is to be homeless. In the oral argument initially, I was kind of surprised. There was only one question Justice Jackson asked about like the HUD definition. She was like, oh, there's these regulations that HUD makes about being homeless. Shouldn't we talk about that? But they didn't want to talk about that in the majority opinion. In the dissent, they also acknowledged the complex causes of homelessness that require a broad range of solution. There was some agreement throughout the whole court on that. But they noted things that I think we all know, which is that resorting to punishment doesn't have a deterrent effect. It ignores the damaging impacts of criminalization, makes getting housing even harder. And it discounts the numerous legitimate reasons a person may decline shelter, including, having a disability, or you can't give your pet with you, bring your pet with you, or you can't keep your family with you, or it's too far and you don't have transportation. I mean, you all know all the reasons why. And they cited a bunch of studies that said that other approaches are more effective in actually ending homelessness for the community. Next slide, please. So the immediate impacts are basically Martin v. Boise is overturned. Any municipalities or counties or states that have these type of ordinances on the books can immediately enforce them. It removes any barriers to those types of ordinances being passed if you don't already have those on your books. Should be noted that states and localities can still decline to criminalize. This court doesn't say you have to. It's not a mandate. It just says you can if you want to. It shifts norms a little bit, particularly in the Ninth Circuit, where everybody was under Martin v. Boise, which is California, of course. And then it reinforces the idea that there's this ideological split in the court. However, it does not invalidate other protective laws and legal theories. So next slide, please. It's important to note that this was a case that was brought up under one legal theory, which was the cruel and unusual punishment clause of the Eighth Amendment. There are still a ton of other methods to make it not criminalization of homelessness. And they include the Americans with Disabilities Act. They include things like the Eighth Amendment also have what's called the excessive fines clause, which means you can't put an excessive fine on something that's disproportionate to what it was actually was caused. So for example, if you litter out your car window, you shouldn't get the death penalty. That could potentially be in violation of the excessive fines clause. So there are some arguments that say, if you don't have any money, if you are experiencing homelessness, really any fine, but certainly a fine of $500 is excessive for someone who can't afford the rent in a location. So Tristia is going to talk in a little bit about different methods, including legal methods, but just keep in mind that all is not lost, that there are these other methods to try and make sure that folks aren't criminalized. So next slide. And then at this point, I am going to talk about the executive order. Forgot. All right, next slide. So folks know in California, Governor Newsom issued an executive order. We wanted to talk about this because I have heard some misconception about this. This is not a mandate for everyone. So the executive order is a mandate for departments that are directly under the governor's control, which includes Caltrans, of course, state parks, Fish and Wildlife, DMV, but they don't really have any property necessarily that this would apply to, they're the ones that have to adhere to this order. And with that, they basically have to adhere to this Caltrans Maintenance Policy Directive, which is about 5 or 6 pages. It requires like a site assessment to determine if something is a high priority or a lower priority. It requires notice, it requires property storage, and it requires coordination with local community-based outreach teams. So state agencies and departments not under his authority are requested to adopt similar policies, but again, they do not have to. And then local governments are encouraged to adopt similar policies, but again, they do not have to either. And then Cal ICH was to develop guidance. So next slide, please. Cal ICH has not issued their guidance yet. All they have out is this 2-page fact sheet. And in that fact sheet, they basically say that they are going to continue encouraging incorporation of person-centered, trauma-informed, and evidence-based approaches to end homelessness. They reiterated that HTD, which is now kind of the new department that's doing all the grants, they're going to issue more IRF grants. They did say that they will be putting forth a series of webinars in 2024 that kind of outlines what their guidance is going to be. And they again reiterated that Housing First is the law in California, and that is what they're highlighting for compliance with any of the programs that they work with. So with that, if anyone has any questions, they are welcome to put them in the chat or raise your hand. But while we're doing that transition, I'm going to go ahead and go to the next slide, please, and hand it over to my colleague, Alex.
See the mentee and all of the ways that criminalization is showing up in our community. One of the things that became clear to me when I was a senior attorney at the National Homelessness Law Center looking at these types of laws across the country is that criminalization shows up in very similar ways across communities. And the tactics are old and tired and harmful. We're familiar with them. They also are varied. And so some of what I want to focus on is, what can we do about the harms and the tactics that are used to punish, and that can include traditional criminal penalties, but punish people for living outside using the law as a weapon. Next slide, please. As Vanessa said, there was a lot of disappointment, of course, in the Johnson decision. It is not a good decision by any means, and it did gut one of the most important tools that we have for challenging criminalization ordinances using the strategy of affirmative litigation. But many tools are still available to us. And so I'll go fairly quickly through some of them. And when I say us, I mean those of us living in the Ninth Circuit. So all of the cases that are listed here provide protections to you as a housed or unhoused person, and all of them are untouched by the decision of the Supreme Court. Affirmative litigation, just to provide some context, is when a group of people sues as plaintiffs, usually a government as a defendant, often challenging the enforcement of a law against that group of plaintiffs or individual plaintiff, and primarily constitutional arguments under the U.S. Constitution or our state constitution are leveraged, but they're not the only types of laws that can support affirmative litigation. And this can be a really important part of a legal strategy. So, first, you have property rights. You have protected property rights, and you do not lose those rights, as Chad said earlier, just because you're not living in what we recognize as traditional housing or a traditional home. First, Levan v. City of Los Angeles, that concerned the city's practice of sweeping, seizing property, immediately trashing it on the basis that the property was unattended, meaning that there was no one there. The city's argument was, well, if it's unattended, it's abandoned, and it can be treated like trash. The court said no. We all have a protected interest under the Fourth Amendment in our property. It's called a protected possessory interest. And another way to think of that is if you own stuff and it's not contraband and you want to keep it, you have a right to keep it. And that cannot be infringed unreasonably by the government. And what reasonableness means in this context includes a balancing of the interest of a person who owns property against the interest of a government in taking that property. But the court found that simply because property is unattended does not mean that it can be seized by the government under the Fourth Amendment. Similarly, you all have a right to not be deprived of your property without what's called due process. And those are all the procedural steps that must be taken before something that you own can be taken from you. At base, what due process means is that you're entitled to notice and an opportunity to be heard before your property can be deprived of you. When you have sweeps, as the city of LA was doing, where your property is destroyed on the spot, just trashed, thrown away, there is no process. That is a violation of your protected 14th Amendment right to due process before your property is deprived. That decision remains intact. Can governments regulate around it and say, well, there's certain kinds of property that you just can't keep because we're making that type of property illegal? The Ninth Circuit said no in Garcia v. Los Angeles. The Garcia case involved an LA ordinance that restricted, among other things, so-called bulky property. And that meant any type of property that couldn't fit into a 60-gallon container with the lid closed. The idea behind that ordinance is if it exceeds that size limitation, it can be seized and destroyed without any notice or process. And again, the court said no, without any procedural protections, you violate the 4th and 14th Amendments. That's another tool that's available to push back on sweeps and property seizure and destruction, which is a huge harm associated with criminalization. You also have a right to be put on notice about what laws are expected of you to comply with. And another way to think about that is the due process clause protects you from having vague laws enforced against you and protects you from selective police enforcement. So vague laws can be like what existed in the Desert Train v. Los Angeles case. In Desert Train, there was an ordinance in LA that restricted using a vehicle as a living quarters. It was enforced against anybody who was apparently living in their vehicle or storing property in their vehicle. And what the court found is that the restriction of using your vehicle as a living quarters wasn't sufficiently defined to put a person on notice as to what conduct they may or may not conduct before facing a criminal penalty and all of the attendant consequences like having that vehicle seized. It also encouraged and led to arbitrary and discriminatory enforcement against people who appear to be visibly poor and unhoused. The due process clause does not tolerate that. And the Ninth Circuit has so found. That's still good binding precedent. And recently we used, meaning the Law Foundation and a number of other entities in San Diego used that precedent to invalidate and negotiate the largest negotiated package of settlement relief for a class of vehicle dwellers in the city of San Diego in Bloom v. San Diego. So these are really useful, effective tools that can push back on some of what we saw as the most common criminalization tactics used locally. The last one I'll just mention it really quickly, is Nunez by Nunez v. San Diego. Now that's a different type of law that was a curfew that was aimed at juveniles, but some of this language is going to sound familiar to you. It restricted loitering, wandering in streets and alleyways between 10 p.m. and sunrise. Who's heard that before? We've heard it a lot. And that violates, or at least implicates, the right to free movement. Free movement is a fundamental right. And one of the things that free movement means is that you have the ability to move at will from one location to another. Why does it matter that it's a fundamental right? Well, if a government wants to regulate and restrict that right, they need to have a compelling reason, and it needs to be a restriction that is narrowly tailored to that compelling reason. That can be a difficult bar to to jump when you are a government attempting to justify what will be experienced as a discriminatory regulation of your ability to move freely from one place to another. And I describe this because, we're seeing a lot of buffer zone laws. You can't come within a certain distance of schools or dwellings. How does this type of restriction on freedom of movement apply under a law that's, a case that's undisturbed by the Johnson decision? What about the other type of regulation where you can be in the sanctioned encampment, but you can't be anywhere else? How does that implicate free movement? These are all open questions and ripe tools for affirmative litigation. Next slide, please. But it's not the only tactical use of attorneys. And I just want to quickly shout out, I absolutely love this GIF. This was created by the Legal Defense Clinic, which is a structure of legal defense clinics that was developed by the Western Regional Advocacy Project and the National Homelessness Law Center that uses the tactic of legal defense, direct frontline legal services to push back on criminalization strategies. It can be used in addition to affirmative litigation strategies. And I want to be clear that all of these strategies should be used in combination with one another in order to be the most effective. But you can provide direct legal defense in citations or tickets. Other things that unhoused people experience, like challenging trespass bans that prohibit a person from entering into some geographic space for some period of time, often lengthy periods of time. You can use it to challenge vehicle tows and impoundment. I know that that's a huge issue that was identified earlier today. Use it to challenge or quash warrants. And these are highly, highly successful tactics. When you provide direct legal services to unhoused people, oftentimes you are successful. And I'll give two quick examples. One is the Los Angeles Community Action Network, otherwise known as LA CAN. That was formed in 1999 by just 25 residents of downtown LA. They were people who decided they were going to organize together to become a force for change, and they focused on the Skid Row area in LA. One of the things that they did, and a thing that we can do here, is implement what they call their Community Watch program. Community Watch is essentially an alternative private security system where the people who are being protected are the people who are likely to experience human rights violations. And in the Skid Row area, that is unhoused people who are having their rights violated by LA Police Department and security guards who are employed by the Downtown Business Improvement District. LA CAN trains and deploys groups of residents to observe and document those rights violations. And what that does is inform the legal defense. So one, you find out what types of defense people need. You collect the documentation and evidence that is being generated through the interactions between enforcers of criminalization policies and the people whose rights are being violated. And the history of success is well documented in LA. Not only have they been able to use that strategy to secure a number of different injunctions, it's no coincidence that the cases that I mentioned earlier emerged out of LA. It's not that LA's so much worse. It's in part that they have organized in order to form effective responses, and they have done that. In addition to using affirmative litigation, the direct legal defense has been highly successful. They have arranged with local attorneys representation of thousands of unhoused people for citation defense. They have something like a 90% success rate in getting those citations dismissed. And even more excitingly, for those who are really concerned with systemic change, they have been able to, through this tactic, reduce ticketing rates in Skid Row by almost 50% using that tactic. Now, is it only LA? Is LA an aberration? Absolutely not. In fact, LA, built upon the foundation that was set by the San Francisco Coalition of the Homeless, which describes itself as a ragtag group of community activists and homeless folks that were, fed up with the lack of response in the city of San Francisco. The coalition, in addition to doing other things, I mean, they created the first supportive housing program in the city of San Francisco. They established Street Sheet, which is, one of the oldest and most enduring unhoused newspapers. They also used direct legal services through partnership with attorneys to demand an end to what was called the Matrix program, which was a program of criminalization, ticketing, and arrests throughout the city of San Francisco. Through the efforts of the coalition, which combined organizing and legal support, they were able to get 39,000 tickets dismissed. Those tickets that had been issued under the Matrix program, they were dismissed. That's not all that they were able to do. They also were able to get the prosecutor to agree to drop issuing warrants for unpaid tickets issued to unhoused people. And that not only had the effect of reducing warrants, it also had the impact of reducing the number of tickets that were issued in the first place. Because if you don't have a warrant to enforce it, then it becomes a lot less useful as a criminalization tactic, which is exactly what you want. And they also, of course, have supported impact litigation and have been highly successful in doing that. In fact, they got a California appellate court decision just last year that said vehicle tows and impoundments premised just on unpaid tickets violate the US and California constitutions. So that's a really important case. You can find information about it on their website. Next slide, please. I'm going to try to fly. One thing that should be said and said again is that the reason why these groups are effective, it's because they are founded on strong organizing, and the attorneys who are working with them use a movement lawyering model. Movement lawyering is not just serving whoever happens to come through the door with direct legal services. Movement lawyering is using lawyers and the skills and strategies that lawyers are able to bring to a movement to support movements led by the people who are most directly affected for the purpose of building power in that community and creating systemic change. Next slide, please. I mentioned it briefly, the legal defense clinic model that was developed. Both LA CAN and the San Francisco Coalition on Homelessness are members of what's called the Western Regional Advocacy Project, or WRAP, that was the leader on developing the history of the Legal Defense Clinic project. You can find a lot more information on wraphome.org, including an implementation manual that will walk you through how, if you're an organizing entity, how you can start something similar to what LA and San Francisco have in their communities. Next slide, please. Organizing is the foundation. Social change doesn't happen without organizing. I believe that very fundamentally. And, an army of attorneys cannot do what an organized group of people can do, but an army of attorneys can help. Having said that, LA, San Francisco, these are large groups. They have budgets. They have well-defined and well-connected leadership. Not every entity or community has that. So I want to talk a little bit about what you can do if you're a smaller group just getting started. How can you start organizing? And I want to use the Gilroy Homeless Union as an example of what can be done even when you are a small group without any funding or without any clear leadership structure. You can still make a big difference and start laying the groundwork to end criminalization in your community. Next slide, please. So the Gilroy Homeless Union was started in response to a camping ban that was enacted by the city of Gilroy, effective in July of last year. And I see that I'm at time, so I'll fly really, really quickly if you don't mind. We had the first ever annual Memorial Day to establish that unhoused people are members of our community. Next slide. We educated unhoused people by targeting that community and talking to them about causes of homelessness. And it was unhoused people who were on the panel doing that talking. Next slide. We have done Know Your Rights trainings. We have 2 more coming up this month. Next slide. We've done community cleanups to show that we are members of the community, just like anyone else who absolutely care about cleanliness and public health. Next slide. And we conducted a survey of nearly 10% of the unhoused population in the city of Gilroy, and asked and successfully got the Santa Clara University's public health seminar to put together a report summarizing the survey findings, which directly combat some of the common stereotypes of unhoused people in Gilroy. All of that was done by people who are currently unhoused with no budget. There's a lot you can do. And thank you for letting me go over time.
Great. Thanks so much, Tristia.
Thank you, Vanessa. Just wanted to close us out and say thank you to everyone who attended. We had over 160 people, and most of you all hung out the entire time. So that is awesome. And I really do believe that we have a moment in time here to fight back. That's what this is all about, right? Right now, and you probably have heard me say this before, but our people are getting beat up. And there's really no organized effort to fight back and think critically about what solutions should actually look like. And so that's what we have the opportunity to springboard from today forward to do. And so that's why, please fill out the survey if you want to continue to be involved. We'll do our best to respond to everything. There was such incredible, offers and engagement in the chat and in the questions today. Obviously, we couldn't get to all of them, but that's really encouraging. I want to say thank you to you, Vanessa, and your team, Michelle, Chris, Tristia. The legal expertise that we have here today, I think gives us additional fuel and opportunity. Supervisor Ellenberg, your knowledge of our system and the root causes of what this is all about and your leadership at the county level is really unparalleled. Super grateful to you. Alex, thank you for bringing your life experience, your passion, and kind of moving those together and really just being transparent, like about, you want to pull on our heart. You pull on our hearts all the time. And I think you have to have a combination of that expertise, that leadership, and the heart in order to really have a movement. So, we're all here today. We're all jazzed. We're excited. We will be following up with anybody who asks us to and want to be part of this. We have some very practical strategies and investments that we plan to make to move this work forward. It will involve all of us doing something different, right? Like we have to work differently with each other. We have to decide to work differently to address these issues. And so we'll be trying to lead on that front and do that ourselves. We ask you to hold us accountable to that, and we'll be trying to hold each other accountable as we move forward. So again, thank you so much. We hope to engage with you in the near future, and I hope everyone has a great rest of the week. Thank you.